Traditionally, those who have been mighty and powerful are the ones who have run to seek the protections of the courts when the circumstances have changed. The courts must continue to give justice to all and sundry, irrespective of their status or former status. What orders should we make in the motion before us? So then, my Lord, I make 3 points with regard to what is public interest as understood by the Court of Appeal. Number 1 is that public interest means enforcement of the constitutions of Kenya. Secondly, my Lord, to make the point from what we have cited, that the first duty of ensuring that you both protect the Constitution of Kenya and you protect public interest is vested in the High Court. Every other court above the High Court, the Court of Appeal, the Supreme Court, they can only do that on the basis that they are sitting in an appeal on a decision already made by the High Court. So that, my Lord, it will be the submission that this reinforces the huge burden that this court must undertake. And, my Lord, the final issue that was being understood here is to say a constitutional democracy would not mean anything unless due process is upheld. And due process is the first duty of the High Court to ensure that in whatever dispute that is before the court, before it is decided, the court has confirmed due process has been observed, and as a constitutional democracy, that is a standard, because they try to compare ourselves with a dictatorship, that as a constitutional democracy, we can live with a decision. As my learned colleague, Mr. Ngoya, was saying, we cannot possibly live with a decision in which we would be seeing the Chief Justice, where, if that were to be the case, you would be seeing the Chief Justice swearing Honorable Kindiki while we are arguing this matter before the court. So that the rules are clear, the rules do not require much elaboration on what they mean. And since that criterion of public interest has been made by the Supreme Court itself, my Lord, I urge you to uphold it in the manner that will best ensure that the constitutions of Kenya and its dignity have been upheld. My Lord, there is the question, so that I believe that we are very clear on public interest, except to emphasize that for the specifics of this case, what does the call of public interest require this court to do? It's a simple call, 5 quick things. Number 1, to confirm that the law on impeachment has been properly interpreted and applied. That's the first issue. To confirm that the laws on impeachment has been properly interpreted and applied. Number 2 is to achieve substantive justice for the parties, so that when a judgment will be issued by this court, at least everybody can win something, that nobody goes home with a hollow victory. That is the whole idea of substantive justice. The third issue is to determine that the issues of the violations of the constitutions is done while the matter is still alive before the court. My Lord, very serious issues on Articles 27, 38, and 50 of the constitutions have been raised. They are all under the Bill of Rights. We urge that while public interest needs to be upheld by ensuring that when this court pronounces itself in a judgment, those issues would not have been turned into academic. Number 4, my Lord, is to ensure that the integrity of the presidential or political succession that is written in express law under our constitution is not rendered ridiculous or ineffective. And in those, I point out what we had said earlier. The desire of the makers of the constitution was any person who will hold the office of deputy president and therefore can potentially become president without an election ought himself to be an elected official. So that it's a big thing if this office, and without good reason, except political malice, is held by an appointed person. It is in public interest that an elected deputy president, except for the clearest of evidence, except for the greatest of sins that are clear to all men of justice, is not removed from office. My Lord, the 5th issue is to do this, that this court protects the constitutions. I've already talked something about it, so I don't have to go much into it. My Lord, there are only two decisions, before I sit down, that I would like to point myself to. There is the issues of Githunguri versus Attorney General. It is one of the cases that are before you. The facts in Githunguri are notorious, and they are also notorious for the simple reason that that decision, those old advocates who are there, Kina Paul Muite and Dr. Gibson Kamau Kuria, tells us that it was largely, though it was a 3-judge bench, it was written in the style of Chief Justice Madan. My Lord, that issue said something that is important to me, the younger advocates in Kenya. And what it said is this: it emphasized the question of justice. And it emphasized the question of justice is the simplest meaning in plain English. You need to ensure everybody has a fair and square deal. This is to say that at the end of the day, everybody will leave the court and says, probably my advocate was not as good as I thought, but the judge did their best. But at the end of the day, let it be very clear that the court did everything that is possible to ensure that justice in its substantive form is achieved. This decision was rendered in 1984, long before the article on 159 was written, and that is why it is celebrated. And my Lord, it is also celebrated, and I am mentioning here for that reason. Whenever honorable men, candidates before the Judicial Service Commissions are called upon to name whose jurisprudence has affected them, it is Justice Madan that is mentioned very many times. I will strive to be like Justice Madan. And my Lord, it is for good reason. All of us celebrate Justice Madan because he strived to do justice. But my Lord, in the same case, the older lawyers also told us about Alan Hancock's, about Dugdale, and even about Chunga. They tell us all these stories. But my Lord, in those interviews, I do not hear anybody saying I want to be like Alan Hancock's. So that, my Lord, I cite Madan in order to support the proposition that Judge Madan would never remove the conservatory orders that are before you, under the principles of doing justice and offering everybody a fair and square deal. The last case that I would want to cite, before I hand over to my learned colleagues, Professor Ogada, has he gone? Oh, I thought whether he has disappeared. But before I hand over to my learned colleague, is to point out to